Well, good afternoon, everyone, and thank you for joining us today. If you haven't done your estate planning yet, this will be a great way for you to at least start thinking about it and hopefully take action sooner than later. We can't stress enough how important this topic is for everyone. Preparing for the inevitable is a tough discussion. It's one that many people find difficult to have, especially with those closest to them. But planning now will lessen the burden down the road on your loved ones as they ensure your wishes are carried out as, as you want. With that said, please help us welcome one of our favorite, Anela Rasul. Anela is the owner and lead attorney of ASR Law Firm, a boutique-style law firm in Boca Raton, Florida. She focuses her practice on estate planning for young families and small business owners, as well as real estate and title insurance. Anela is a member of the Florida Bar and earned her JD in 2006 from Nova University. She is originally from Toronto, Canada, and now resides in South Florida. Anela?
Thank you so much, Rania. I appreciate that. And thank you for everyone for joining us today. As Rania mentioned, my name is Anela Rasul. I'm the owner of ASR Law Firm in Boca Raton. And the focus of my presentation today is to explore some of the less discussed aspects of estate planning for married couples, particularly newer married couples, as well as go over some of the needs for certain financial plannings that go along with your estate plans. A lot of us, we've all heard about the important basic documents that we should all have: the last will and testament, the living or inter vivos trust, your durable power of attorney, your medical advance directives, that sort of thing. But today I want to delve a little deeper into the subject and kind of go over some of the important considerations that married couples need to consider when they're drafting these documents. So, in my experience, newly married couples of any age, they're most likely to need to either create or review or revise their estate plans. And this makes sense because due to the significant changes in who are going to be their beneficiaries or their agents, they're going to need to revise everything. Essentially, these individuals, they're shifting from having people like, let's say, parents and siblings being the most important family members in their lives to the couples themselves. And of course, as their family grows, so does their need for protecting their assets and for appointing appropriate fiduciaries. So there are 4 areas that I'd like to discuss, and they are: 1, the need to update their plans and create their plans. 2, the need for or examining Florida's elective share. 3, that's providing for your children and the children involved. And then 4, the final one, the need for a financial and insurance planning for what we call the sandwich generation. So, the first area that I like to discuss, and what I usually start off with newly married couples, is the need to update their estate planning documents. So truth be told, in my experience, few younger unmarried individuals have estate plans. Although I have to say 2020 is making a big change to that trend. But those who do have estate plans, they usually name their parents or their siblings as their beneficiaries and as their trustees or their agents. And that makes sense because up until getting married, those are the most important people in your lives, or the most trusted, at least. After marriage, however, many never even think about updating their documents, or they believe that there's no real need since their estates are so small and they don't have any accumulated wealth or accumulated assets. Some of my clients actually mistakenly believe that their spouses just will automatically get all of their assets because now they're married if they unexpectedly pass away. And whereas spouses generally are first in line to get deceased spouses' assets in cases of intestacy, and that's when people pass away without a will. It's not necessarily the case if a person dies having a will and naming other beneficiaries, or having other beneficiaries named as on financial accounts and things like that. So an example of this that I encountered recently, I had a couple who were about to be married contact me. Actually, the to-be wife contacted me because she wanted to get some assistance with putting together her estate planning document. And as it turned out, the to-be husband, he apparently didn't see this as much of a priority because he believed that all of his assets would just automatically go to his wife after they got married if he unexpectedly passed away. His assets, if I recall correctly, they included, among other things, an investment property that he held, he co-owned with his brothers, as well as a few investment accounts and financial accounts in which he named his parents as beneficiaries upon his death. So after I explained to him the possible outcomes of his specific situation, then he realized, oh, well, his intention of what he wanted to leave behind would not necessarily happen if he didn't clearly state his intentions in his estate plan or make changes. So luckily, after our conversation, he was far more amenable to creating not only an estate plan, but then I also got him to explore some other insurance options and financial options. And in my world, this is considered a big win for the day. So it was definitely a success story that I like to share. I've also had clients tell me that, they've spoken to their parents and they trust that their parents would take care of their spouses at the end if they unexpectedly passed away. Now, even if you're 100% sure that your parents will do the right thing and turn over your estate to your new spouse, well, first of all, there's no guarantee that that will actually happen. And secondly, there are a list of reasons why you really don't want to list your parents, especially those of us who have aging parents, as your beneficiaries or your agents. The things that the reasons I commonly discuss with my clients, are one, well, the inevitable. It's the greater likelihood that your parents are going to predecease you, leaving you with the need to update your documents again. So why not do it and add your spouse in and if you have children now, as opposed to waiting until later. Secondly, any additional assets, should you predecease your parents, any additional assets that you do leave to your parents may alter their tax obligations. And this may be something that your parents are trying to keep to a minimum as they get older. And then thirdly, for those of us who have parents who reside in nursing homes, etc., just blanketly transferring assets to a parent's account may, depending on the types of contracts they have with these nursing homes, may allow the nursing home and other such facilities to attach to those funds, which may not be your intention. So now, aside from changing the beneficiaries on your estate planning documents or on accounts directly, newly married couples should also consider who should serve as their agents, so their personal representatives of their will or the trustees of their trusts. And although spouses usually name each other for these roles, if they choose to select a successor agent or just to name someone entirely different entirely for the role, they should consider these, at a minimum, should consider these following concerns. One, the ability and competence of the person chosen. If you are choosing older parents, they may not be the best suited to manage all the duties of being a trustee of an estate. There's a lot of coordinating, a lot of work to be done, and they just may not have the ability to do so. Two, the dynamics and the dynamics of the family, and then the trust that you have in that named person. For example, why would you name your estranged brother, even if they may only be your only sibling? Not only do you want to trust the person would live up to their fiduciary duties, but you also want to make sure that they're familiar enough with your preferences so that they can properly carry out your wishes. And then three, the geographic convenience. It may not make a whole lot of sense naming your sister who lives in Alaska if you live in Florida, for obvious and practical purposes. Now, these considerations, they not only apply to choosing your your trustees or your personal representatives, but also who may act as your healthcare surrogate or even an agent on a durable power of attorney. Again, it's really important that you choose someone who you trust implicitly and who also will have the emotional ability to carry out these responsibilities when needed, because needless to say, they are going to be doing these things at a time when you'll be passed away, so they'll be very emotional at that time. This is usually why spouses name each other. They know intimately what each other wants, and they have a history that will allow them to properly carry out these functions. So this brings me to the second area I'd like to discuss. Now, if you and your spouse truly agree that you prefer your parents or your siblings to remain as beneficiaries, and I see this a lot, people do this, they tend to do this as somewhat of a good faith gesture to repay parents for paying for their education or for helping with the down payment of a house or something like that. You must remember that in Florida, spouses have special protections. A couple examples are, for example, homestead rights or something called the elective or spousal share. Florida law, specifically Florida Statute 732.201, they protect spouses who have been inadvertently forgotten or even purposely disinherited through its elective share laws. This law allows a surviving spouse who has been disinherited in some way to elect to receive 30% of their deceased spouse's estate, regardless of what is stated in that deceased spouse's will or estate plan. So the history of this is that years ago, before the prevalence of women in the workforce, this law was first enacted to protect wives who were being purposely disinherited by their husbands who chose to leave all or most of their assets to their mistresses, thereby leaving this mother who typically did not work outside the home with the need to provide for herself and for her children, leaving them without anything. But of course, today it applies to both spouses equally. With this election, a spouse who has been disinherited somehow can attach to almost all the assets of the deceased spouse, including property owned with others having a right of survivorship, payable on death accounts, contents of revocable trusts, death benefits associated with various types of retirement plans, that sort of thing. So for this reason alone, it's imperative that spouses adequately protect for each other in their estate planning, just to avoid assets not being distributed in the way you intend. So to illustrate this, consider this scenario. In a case where a deceased spouse truly intended to name, let's say, a parent or a sibling as a beneficiary upon their death on a bank account, a surviving spouse who was not sufficiently provided for in the will can attach to the assets of that account to make up their 30% share. And the end result is that what you intended to leave to your parent or your sibling or whomever, they would not receive that asset, and it will go to your surviving spouse. Now, even if both parties agree during their lifetimes that they want to leave the lion's share of their assets to someone else other than each other, and this is very common with subsequent marriages, where there are other children outside of the particular marriage, that sort of thing, the surviving spouse can still change their mind after the one spouse has passed away, and they can elect for that 30%. They can elect their spousal share. One way around this is that the spouses, if they agree, they execute a prenup or a postnuptial agreement waiving any rights to the elective share that they may each have if the other passes away. That is, those kinds of agreements are usually done by family law attorneys or marital law attorneys, not necessarily your estate planning. All right, now that takes us on to the third area, and for many of my clients, the most important area, frankly, of their estate plan, and that's really accounting for the children and protecting the children if they both happen to pass away. So adding to this complexity now that married couples find themselves in being married is how do they account for the children in terms of what are the logistics of leaving assets to minor children, as well as appointing guardians and the guardianship of their minor children. So the logistics of leaving assets to minor children can be really difficult. I mean, for example, think of this. How do you leave, let's say, a vintage vehicle, a vintage car to your 5-year-old, or expensive jewelry to a preteen who really has no appreciation of its value? So what many parents do is they will use a trust as a vehicle to leave specific detailed instructions as to what, when, and how assets can be passed over to their children and for what they may be used for and how the children may benefit from it. These trusts, they can either be written into their wills, or it may be part of a separate living trust that becomes irrevocable upon the parents passing. What many of my clients often realize is that some of these assets are easier to deal with than others. So for example, leaving cash or investments may be somewhat simpler to leave to their children than other assets like real estate. This is partially due to the ability to create things like custodial investment accounts, that sort of thing. But the question that still remains is, who will manage these accounts and other assets for their minor children? For example, if they leave, let's say, real estate to be sold to fund an account for their children, and that was their plan, who was going to handle the sale on their behalf? It's in these trust documents that parents typically clearly state who will manage the accounts or assets on behalf of the children, when the children may receive assets, and what portions of these assets they can receive, as well as how can these funds be spent to upkeep the standard of living that the child and the children are used to. So over the years of helping parents prepare these documents and make these considerations and these decisions, it's clear that most of them know how they want the assets to be divided and what they want their kids to have. The bigger question really is selecting the fiduciary to help their children along with that. So, excuse me, that takes us to the second area of concern, and that is the selection of the guardian for their minor children. So a guardian serves as a long-term caretaker of a minor child up until they reach the age of majority. Needless to say, selecting the appropriate person to be the guardian of your children is equally as challenging as it is important for a parent. Most couples, they typically turn to their parents, or especially younger couples, they typically turn to their parents as the preferred guardian for their children if they both should pass away. However, this is not the best option, or at least I don't believe it to be the best option, because as the child gets older and presumably their demands get higher, so does the grandparent. The grandparent gets older too, and that the ability to manage the child and to care for the child tends to diminish. So they look to select, a lot of clients look to select other family members, such as siblings and things like that. But that may also pose its own set of issues, such as introducing your child into a family that already has children. And then this new guardian has the responsibility of kind of managing these two groups of children and allocating resources accordingly. I've seen this become especially problematic where the deceased parent leaves behind a large, let's say, insurance payout or whatnot to care for their children. And then the guardian then has to learn and adapt to allocate these funds accordingly and fairly amongst now these additional children that is in the household. In fact, I recently had a client who was dead set on having her cousin become the guardian of her kids should she and her husband pass away, over, I believe, even over her brother, because her cousin had kids, they were very close with their kids, and they were very close to the family in general. But she knew that any funds that she would leave behind for her children would provide a far better lifestyle than her cousin could afford on her own. So within the provisions of her trust, she allowed for certain expenditures, such as I believe like yearly summer vacations, that the cousin's family could also enjoy along with her family at the expense of the trust. And this was just one of the ways, and something that she considered, and one of the ways to eliminate any potential conflict could arise amongst the guardian's family and her children because of, the additional or the funds or the additional amounts of money that the guardian's family may perceive her children to have. So you can see there's a lot of factors to consider when choosing both the trustee and a guardian for the deceased minor child and their families. I always tell my clients, in making this decision, this important decision for who's going to be the guardian of your children or be their financial fiduciary, there really is no perfect choice. There's only really the least bad choice. And that tends to make the decision easier for them. Now, that brings us along to the final area of concern that many married couples find themselves. They find themselves in between two generations. Excuse me. And they are now often what's called the sandwich generation. And because they're providing not only for their young children or minor children, but they're also in some forms taking care of aging or elderly parents. This can be financially stressful and damaging to families, especially young families with limited assets. So I always advise my clients that the best way to successfully balance and tackle this responsibility is not only to have a well-established estate plan and those documents in line, but also to make sure that you are financially protected should the inevitable happen. Now, this is a perfect example of where estate planning professionals and attorneys and insurance and financial planning professionals work together to create secured plans for their clients and comprehensive, all-encompassing plans. So, for example, actually, that client that I just mentioned who selected her cousin to be the guardian of her children, she funded her estate with a life insurance plan with very, very high payouts upon her and her husband's passing. So there was a lot of coordinating between my office and her financial advisor's office to ensure that she was properly covered and what she really intended would happen, given what she had in place for her estate plan and her financial plan. So another thing to consider is that having financial assets that are easily liquidated to fund the estate plan is imperative to properly protect your family, especially when you have younger kids, and then you have the added responsibility of juggling how will your assets have to be administered in order to benefit your family. The objective is always to conserve as much of your estate as possible. So the more liquid your estate and easily transferable, the better. For example, if all of your assets were real estate and your intention was to have those assets and those properties sold to fund an account for your family after you pass away, then you have to remember that a significant portion of the value of those assets, those properties, will be spent on facilitating the sale and the liquidation of those assets, and not necessarily be passed on to your family directly. So this is a perfect example of how vehicles such as life insurance and that kind of planning and financial planning becomes especially important to your estate plan, because it allows you to leave behind cash money for your family to maintain their standard of living. Now, similarly to estate planning, financial and insurance planning is done not only in contemplation of an untimely death, but also in the case of unexpected long-term disability. So this is particularly important for many of my clients who are the main financial providers of their family. Today, admittedly, is both parents. So because of this, I always recommend to my clients to explore options for long-term disability insurance that will complement whatever type of life insurance policies they have and other estate planning protections that they've put in place, just to provide that extra bit of security and cash benefits for their family members if they can no longer work. These financial and insurance options that I'm kind of alluding to, it allows this sandwich generation who has quite a bit of responsibility to insure themselves to the extent needed to care for their minor children, as well as their aging parents, as the case may be. It allows them to be as protected as their particular circumstance demands at any given time in their life. And it's these options, together with a properly drafted estate plan, that allows my clients and married couples the confidence of knowing that their bases are covered and that their families will be taken care of in the case of either a long-term disability or an untimely death of either parent or both parents. So with that, I come to the end of my list of the most common concerns and the most important things that I usually discuss with my clients who are married couples and what they can expect to encounter when creating their estate plans. I hope that that you found some relevance in this and value in this information. And so I'll turn you over at this point back to Frank and Rania, and I can answer any questions at the end.
Thank you so much, Anela. That was great information. As parents and grandparents, there isn't much we wouldn't do for our children or grandchildren, including making sure they are secure and when we're no longer around to take care of them. And I love the fact that you did address disability insurance or income protection and long-term care, because technically numbers have shown over the years that at least 50 to 60% of people will need long-term care at some point in their life. And I have to say, from my own personal experience, I have been through it twice. My father had dementia and he did not have long-term care, but thankfully he had me and my sister to take care of him. And it was about 7 to 8 years where he was going through the whole process. And thankfully, again, we were there for him. And he passed away a couple of years ago. And now I'm going through it with my stepdad. He was in a nursing home for 2.5 years. He did have long-term care, thankfully for that. But my mom found out recently that because of COVID and she wasn't able to visit on a daily basis, they were not taking care of him as much as she wanted him to be taken care of. She brought him back home. So I see this every single day, and it's an epidemic. I don't want to say pandemic. It's an epidemic that we see on a daily basis. We can cover life insurance, but it will take a lot longer than a couple of minutes for us to cover that. So I'd like Frank will take over and speak a little bit more about income protection and long-term care.
Well, thanks, Rania, and thank you, Anila, for a great presentation and a very nice segue into what it is that we do as financial advisors. And I would like to say that we're comprehensive. We don't focus on one side of the coin or the other. We firmly believe that wealth management and risk management go hand in hand. You really cannot have one without the other. Since we're still on the subject of long-term care, I'll just briefly add that Long-term care has no age. Typically, a lot of people feel that planning for that shouldn't happen until your middle 50s or even your early 60s. And unfortunately, what we're seeing as advisors today is that younger people are not able to qualify because of health issues or other issues in their personal situation for life insurance, let alone long-term care insurance. And the cost of purchasing long-term care insurance today is very, very inexpensive. There are a couple different ways to do it. We will not go into that today. But my point being is that the sooner you address this situation, the better financially you're going to be, because your assets need to be protected, not only while you're working, but when you're in retirement. And when it's too late to get it because you are too old or because your health doesn't allow you to get it, then your assets are going to be at risk. The story on my end is that my mom is 95. My aunt passed away in January at 96. Both of these ladies were living a life that they just didn't deserve. My aunt had long-term care, but it was a very small policy, and we were paying close to $12,000 a month for 24-hour care just for the home health aide. So it can be a very, very expensive endeavor that needs to be addressed, and the sooner that you plan for it, the more better off you're going to be. The other thing too that's very complicated is that my mom lives in Chicago. I'm down here in South Florida. If it wasn't for my brother, I can't imagine that I'd still be down here. I would have to move up there to make sure things were getting taken care of. Regarding income protection, and this is where we'll close things out, this is something that I am extremely passionate about. It was when I came into the industry of financial services, it was the first thing that I took care of, because I really believe that without your income, without the ability to go to work and earn a living, everything that we have is at risk. And we put plans together for people with the intention of being able to fund them till retirement so that they can then use those funds to retire on. The problem is that if or when you become sick or hurt and can't work, you don't have the funds to continue putting away. Therefore, not only is your current lifestyle at risk, but your future lifestyle is at risk. So this is an area that we discuss with everybody. And you know, the old phrase, something is better than nothing. I truly personally believe that this is a part of everybody's financial plan that needs to be addressed. If you take someone that's making $100,000 a year, that's 35 years old, the next 30 years without even getting a raise, that's $3 million of income. And we protect or insure things like our car, our homes. Some people insure their cell phones, but we're not insuring the one thing that makes us able to pay for everything else that we have, and that is your income. So it's a very important feature. And again, when we are working with estate planning attorneys, even business planning attorneys, these are the subjects and things that come up in conversation and that we make sure do get addressed. So with that, I'll end the presentation. Does anybody have a question at this point that we might be able to answer for you while we are on the call? Okay, then I guess we have clarity on today's subject matter. I want to thank everybody for attending. I want to thank Anila for presenting. That was a great presentation, very thought-provoking and very informative. This is the first of a number of webinars or virtual webinars that we're going to be doing with Anila, so please watch out for the time and date of the next one. Invite your friends, invite your colleagues, spouse, significant other, whoever you think can benefit from this. The subject matter is going to change a little bit each time we do this, but it's all going to be relative to the same planning tools. So thank you everybody for being on. Stay safe, stay healthy, and we'll see you next time.